Good afternoon, ladies and gentlemen. Thank you very much for taking the time out of your busy schedule to be here today. What I would like to talk about this afternoon to you is the emerging legislative discussion on new neighboring rights for publishers and other proposals.
It is expected that demands for electronic books will significantly expand with the spread of e-book devices. The existing environment of the publishing industry, which the copyright law is based on, is dramatically changing. In Japan, establishing new rights for publishers with regard to copyright laws has been up for debate for the past 2 years. In this presentation, debates over the pros and cons of establishing such new rights or of extending their existing rights will be considered. The publishing industry in Japan has been in recession for years. The market size was 2,656 billion JPY in 1996, however, it declined to 1,874 billion Japanese yen in 2010. It has reduced 30% from 1996. In contrast, the e-book market has been gradually increasing in Japan from 46.4 billion JPY in 2008 to 65 billion JPY in 2010. It is expected to be around 200 billion yen in 2015. In this situation, publishers established an association, the Electronic Book Publishers Association of Japan, in February 2010 to work toward promoting e-books and conduct studies. The government also established an advisory council to discuss this issue. Copyright interests can be transferred from the author to third parties. However, there is a tradition that Japanese publishers do not demand that authors transfer their copyright in the contract. Japanese publishers only have a license to publish the books. In addition, it is impossible to file a suit against infringers without the permission of the copyright holder, even if the publisher has an exclusive license from the copyright holder. This system is different from that of other countries like the UK and the United States, where the exclusive licensor has the right to file a suit independently. Under the copyright law in Japan, publishers have no exclusive rights, except that they make the contract to establish their right of publication with the authors. Japanese Copyright Act Articles 79 and 80. However, this right of publication is limited to the publication of the work in written or printed form and cannot include certain form of e-books. This slide illustrates it again. It is impossible to file a suit against infringers without the permission of the copyright holder, even if the publisher has an exclusive license from the copyright holder. This system is different from that of other countries like the UK and the United States, where the exclusive licensor has the right to file a suit independently. Under the copyright law in Japan, publishers have no exclusive rights, except that they make the contract to establish their right of publication with the authors. Articles 79 and 80 of Japanese Copyright Act. However, this right of publication is limited to the publication of the work in written or printed form and cannot include certain form of e-books. It is practically impossible for individual authors as copyright holders to deal with the issue of illegal digital books distributed over the Internet. On the other hand, although publishers can commence proceedings to seek injunctive relief against paper-based illegal publication due to establishment of the right of publishing, they have no original power to exclude illegal distribution over the Internet under the Copyright Act. Authors can make a contract with other publishers, B in this slide, as regards the publishing of e-books even if the author has already made an agreement with publisher, A, in this slide. It is possible for publisher, A, to make a contract that forbids the author from publishing the e-version of their books from another publisher. The publisher could sue the author for a breach of the contract. However, practically, such cases are almost never seen. In the above situation, a publisher's position in Japan is relatively weaker than in other countries. Japanese publishers are now lobbying to establish new rights with regard to neighboring rights for e-books. Supposedly, there are at least 4 options for this agenda. Option 0, do nothing. My proposal, option 1, a study group on infrastructure development of print and digital cultures released its legislative proposal for a right of publication. Option 2, proposal for the establishment of a right of digital publishing to facilitate distribution and exploitation of digital books. Option 3, legislate to grant an exclusive licensee in common a right to seek injunctive relief. Option 0 is my preferred option. It can meet policy objective with the lowest level of risk. There are no international agreements with regards to publishers' rights. Therefore, the system is different in every country. For example, the UK and Australia has a published edition right for publishers, and EU countries have publication rights under the EU directive. On the other hand, the United States does not have any such right, and publishers have an exclusive license to publish. In countries like UK, Australia, and USA, the exclusive licensor has the right to file a lawsuit against infringers independently, which is different from the exclusive license in Japanese. The CDPA 1988, Section 102 states that 1. Where an action for infringement of copyright brought by the copyright owner or an exclusive licensee relates, wholly or partly, to an infringement in respect of which they have concurrent rights of action, the copyright owner or, as the case may be, the exclusive licensee may not, without the leave of the court, proceed with the action unless the other is either joined as a plaintiff or added as a defendant. 2. A copyright owner or exclusive licensee who is added as a defendant in pursuance of subsection 1 is not liable for any costs in the action unless he takes part in the proceedings. 3. The above provisions do not affect the granting of interlocutory relief on an application by a copyright owner or exclusive licensee alone. For trade publication, the publisher will require the volume form publication rights and electronic form publication rights to be granted by each author by way of exclusive license. In the case of professional, academic and encyclopedia works, an assignment of the entire copyright in the work will be required. Employed writers and editors and regular contributors to magazines will normally be required to assign the entire copyright in their work. Academic or scientific journals tend to require a full assignment of copyright from all contributors, but they permit contributors to reuse their materials. Other professional journals tend to require simply non-exclusive right to publish. Electronic publishers require an assignment of full copyright. My point here is that the practice varies in the type of publishing in the UK. In June 2012, a study group on infrastructure development of print and digital cultures released its legislative proposal for a right of publication. Person who produces an original compilation of publications, etc. will be given a neighboring right for original compilation of publications, etc. According to this proposal, the primary purpose is to provide countermeasures against the pirating publications. The secondary purpose is to promote the use and distribution of publications, especially digital books. Introduction of this right will allow a publisher that manages all publications of a work to take an action of its own initiative against infringement of his rights. The right will have additional effects on promotion of the use and distribution of such works. 2. Form of the legislation. This legislation should be introduced by partial revision of the Copyright Act. 3. Definition. Original compilation of publications, etc. The phrase original compilation of publications, etc. refers to manuscripts or other originals or other equivalent items and electromagnetic records, which are edited to the quality necessary for their publication in a written or printed form or other equivalent electromagnetic record. The phrase manuscripts or other originals includes those writings that are literary works, musical scores, as musical works, and originals of artistic works and photographic works. The words other equivalent items mean the reprographies of manuscripts and music scores or the publications of existing copyrighted works. The words other equivalent Electromagnetic records refer to the electromagnetic record equivalent to the original. The words in a writing or printing refer to works reproduced directly on a tangible object by means of letters, characters, illustrations, pictograms, etc., that also take the form of directly visible reproduction of the works and other materials. Therefore, electromagnetic records such as a hard disk, which displays characters by means of computers, or records on DVDs and other media are not included within the meaning of in a writing or printing or other equivalent electromagnetic records because those records per se are not visible. The term publication has been construed as meaning to reproduce a work in a writing or a printing and distribute those reproductions through publication. However, considering the fact that digital books have become increasingly popular and have spread rapidly, it could be the case that a reproduction and a digital transmission of a digital book also should be included in the definition of a publication in a broader sense. Discussions around this issue should continue. The words qualities that are necessary for the publication indicate that the manuscript must be at the final stage necessary for print or delivery, the edition is ready for the press, data files are written in the format of digital publication, etc. It is not necessary to actually print or deliver. Even after mechanical operations such as editing and DRM treatment, the material is subject to protection as long as it maintains a quality of sameness. The words editing/compilation mean the collection of materials under a particular concept or purpose and compiling them into books, magazines, newspapers, etc. That is, the entire process undertaken to produce publications based on an author's manuscript. So-called rich content refers to a digital book which includes voices, music, and movies. These do not fall within the scope of the term publication here. Person who produces an original compilation of publications, etc. The person who produces an original edition of publications, etc., means a person who produces such an edition in his or her name. Printing companies and editorial productions, which undertake the work on request, are not included in this definition because they do not produce the publications under their own names. It is not required for the person to engage in publishing in the course of their trade. 4. Contents of the right. A person who produces an original edition of a publication shall have, as neighboring rights, a right of reproduction, a right to make such transmittable, a right to transfer ownership, and a right of rental. Right of reproduction means as follows: the owner shall have the exclusive right to reproduce his original edition of the publication. Right to make such a work transmittable means as follows: the right owner shall have the exclusive right to make his original edition of the publication transmittable. Right of transfer of ownership means as follows: the right owner shall have the exclusive right to offer his work to the public by transferring ownership of the reproductions of his original edition of the publication. Right of rental means as follows: the right owner shall have the exclusive right to offer his original edition of the publication to the public through the rental of reproductions of the work. The grounds for these neighboring rights are: 1. The protection of quasi-creativity and the communicative role of such publications, and 2. The protection of a person who has a role in transmitting such materials to the public. When these rationales are applied to publishers, we see that 1. A publisher operates backup editorial works of creation cooperatively with authors, and 2. A publisher incurs the costs relating to production of books and other items, distributes the income to authors, and makes a profit as an intermediary for distribution of these publications. From this viewpoint, there would be reasonable grounds for granting a neighboring right for a publisher. 5. Term of protection. The beginning of the protection. Protection would begin with the production of the original edition of publication. 5. Term of protection. Duration of the right. The duration of the right shall be calculated from the year when the publication was made. Further consideration should be given to the issue of duration. It may be proper to adopt a period of 20 years similar to that in other countries in order to harmonize with other neighboring rights. Option 2. Right of digital publishing under the licensing agreement. Japan Business Federation, Keidanren, on 19 February 2013 announced the proposal for the establishment of a right of digital publishing to facilitate distribution and exploitation of digital books. The concept of a right of digital publishing is similar to the existing right of publishing in the current Copyright Act. A right of publishing is a right established in accordance with the contract between the party obtaining the right and the owner of reproduction right. The owner of the right of publication shall have 1. The right to reproduce, 2. The original text of the work, 3. In written or printed form, 4. By means of typography or other mechanical or chemical processes, 5. For the purpose of distribution. Under the Copyright Act, a right of publication is a part of a reproduction right. The publication right can be given only by signing a contract of establishing a right of digital publishing on the basis of the copyright owner's reproduction right, which is a right to prohibit unauthorized reproduction. Therefore, it is different in character from a copyright and a neighboring right, which are granted automatically. With regard to duration, while the publication right expires 3 years after the date of the first publication, in the absence of such an agreement, the current neighboring right continues to exist until the end of a period of 50 years from the creation of the right. Additionally, in accordance with the requirement that the reproduction should be formed by means of typography or other mechanical or chemical processes, a right holder of a publication right does not have exclusive rights to create and distribute a digital form of books or to make a claim for injunctive relief against the unauthorized creation and distribution of digital books. In addition, the owner of the right of publication may not sublicense that right to any third party. Compared to this, the proposed right of digital publishing would be established by converting the phrase by means of typography of other mechanical or chemical processes to be electromagnetic means, or by altering the phrase in written or printed form to read in a digital format. The interactive transmission right grants a right holder of digital publication rights exclusive rights to create and distribute a digital form of books as well as to claim for injunctive relief against the unauthorized creation and distribution of digital books. As it is considered to be more important for digital books to ensure an appropriate distribution in contrast to paper media, it should be designed as a right that can be sublicensed to others. 1. It is given to a person who undertakes to publish a digital book. 2. The right will be given by signing a contract to establish a right of digital publishing. 3. The publisher should have an exclusive right to reproduce and interactively transmit the work in a digital form. The effect of this is to allow the publisher a right of injunctive relief. 4. The right should be available to sublicense to any third party. 1. Those who undertake to publish digital books are not always publishing companies or persons who otherwise publish paper media. It is preferable to facilitate new cross-industry entrances for the future. Therefore, the right should be given to a person who undertakes to publish the digital books, not to a publisher. 2. The foremost interest of concern is the rights of authors. Therefore, the resulting system should not allow a person who publishes digital books to exercise his or her right without regard to the copyright owner. Consequently, the right of a person who publishes digital books can be given only by signing a contract to establish a right of digital publishing. Since the execution of the contract requires an agreement by the party, it will ensure the intent of the copyright holder. Exercising the right of injunctive relief by "the right holder of digital publishing will then have the same meaning as protecting the right of the copyright holder. To establish a right of digital publishing, it helps to facilitate the practices of a contract within a document between the copyright holder and the digital publishing rights holder. 3. Under "the contract to establish a right of digital publishing, The right holder of digital publishing will have the exclusive right to reproduce and interactively transmit in the digital form. This effectively allows the right holder of digital publishing to hold himself a right of injunctive relief against the illegal distribution of digital books. 4. Since digital books are likely to be distributed not only by the right holder of digital publishing himself but also by a distribution company, among other companies, the facilitation of distribution will be ensured by allowing sublicense of a right of digital publishing to any third party. Cadenron states on the option 3 as follows: given the potential for future development of the content business as a whole, including the creation of rich content digital books, it is true that it is inadequate to limit the discussion only to digital books. From now on, as previously stated, we should open a full-fledged discussion of the issue of granting an exclusive licensee in common a right to seek injunctive relief by revising the current law. The merits of forming this right as a neighboring right. A publisher can take his own legal action to protect his rights. Since a copyright owner can publish his work as a digital book through a publisher other than the original publisher, even after the initial publication, these rights will promote free competition. According to Cadenron's proposal, the following problems are pointed out for the option of new neighboring right. 1. An insufficient correlation with development of the digital book business. 2. The effectiveness of anti-piracy measures for rights infringement of publication is questionable. 3. The practice of exchanging a written contract should be facilitated. In its proposal, Cadenron states as follows: it is difficult to realize a right of injunctive relief held by an exclusive licensee in the short term. Given the current serious damage caused by the distribution of illegal digital books that the digital book business has been facing, as a first step it would be effective to confer a power on publishers that allows them to compete with illegal digital book distribution. This proposal applies the basic idea of the existing right of publishing to digital books. Therefore, it is capable of addressing infringement on the Internet without posing harmful effects to other stakeholders. Cadenron's proposal says that the United States, a contract society, has established a model based on contracts in the field of digital book business. There, the copyright owner makes a copyright transfer agreement with the publisher to transfer his copyright to the publisher. The contract terms relating to digitalization of books and so forth are written in the contract. In addition, a copyright owner normally uses an institution or person called an agent, which serves to mediate the negotiation with publishers on behalf of the copyright owner. On the other hand, publishers in the United States are not given any special rights such as a neighboring right. In contrast, even before dealing with the matter of digital books, the Japanese publishing industry has not been able to implement the business models accepted globally, in that they do not have any well-established practices for use of a written agreement between a copyright owner and the publisher. It is considered to be difficult for our publishing sector to maintain a Japanese-style business model in the future, which is based on a relationship of mutual trust between a copyright owner and a publisher without exchanging a written contract. In Japan, it is necessary to search for resolutions including setting up the business practice by which a copyright owner transfers his copyright to a publisher under a contract, as in, for example, the United States. Proposing a digital publication right that could not be established without any contract could assist to establish a contract culture in our publishing sector. Problems with the idea of extending a current publication right. It would be difficult not only for a copyright owner himself but also for other publishing competitors to publish a digital form of books under such an extension. Accordingly, the extension could impede the distribution of publication through digital media. Considering that there are few cases in which a copyright owner establishes the right of publication, such an extension is not likely to provide sufficient protection against pirated publications. Cadenron's proposal states in its paper that, currently, While there are various discussions over how to develop the digital book business, some people in the publishing business have proposed that the law provide a neighboring right/related right for publishers. However, this would produce significant side effects. Primarily, there is a possibility that the intent of right holders may not be given first priority. It is to be expected that the increase in the number of right holders would prevent the distribution of works, among other things. Legislation might be proposed to resolve this problem. However, considering that in order to promote an entire field of business relating to copyrighted works in the future, it is preferable to give an exclusive licensee the right to seek an injunction under a revision of the current Copyright Act. This legal amendment, in the field of the digital book business, would make publishers file an injunction even if they made an exclusive license agreement with the copyright holder. However, it is difficult to realize a right of injunctive relief held by an exclusive licensee in the short term because the scope of involved copyright holders and users would be largely expanded, and the discussion may affect issues such as a balance between that right and other intellectual property, including patent rights.
It is considered to be difficult for our publishing sector to maintain a Japanese-style business model in the future, which is based on a relationship of mutual trust between a copyright owner and a publisher without exchanging a written contract. It is possible to ensure stable enforcement by stipulating the obligation to eliminate infringements in the exclusive license agreement so as to ensure, in practice of contract, asserting the right of subrogation by a publisher as obligee. It would be possible to construe existing Civil Code Article 423, to allow a publisher to bring proceedings. Under Article 423, Para 1, the obligee may exercise a right belonging to the obligor, in order to ensure the performance of a monetary obligation by the right of subrogation. Although the right of subrogation was designed to ensure the performance of monetary obligations, the right of subrogation of the obligees diverted to a measure to achieve the purpose of non-monetary claims, specified claims. The obligee may exercise a right belonging to the obligor, in order to ensure the performance of certain non-monetary obligations. It is possible to ensure stable enforcement by stipulating the obligation to eliminate infringements in the exclusive license agreement so as to ensure, in practice of contract, asserting the right of subrogation by a publisher as obligee. Conclusion. As I mentioned in this presentation, granting a neighboring right for publishers would be unnecessary and would produce significant side effects. Considering the UK business practice in the publishing sector, the type of license depends on its form of publishing. Additionally, in the particular circumstances, an assignment of full copyright will be required to facilitate exploitation of the works and necessary to tackle with pirating publishing at home and overseas. It would be reasonable to follow the practice of the UK publishing sector, which has achieved great success in the global publishing market. As of this moment, I am not sure it is a good idea to introduce a new digital publication right as proposal of Kai Danron. First, it might be possible to construe the existing Civil Code Article 423 to allow a publisher to bring proceedings if he is an exclusive licensee. Under Article 423, Para 1, the obligee may exercise a right belonging to the obligor, in order to ensure the performance of a monetary obligation by the right of subrogation. Although the right of subrogation was designed to ensure the performance of monetary obligations, the right of subrogation of the obligee has been diverted to a measure to achieve the purpose of non-monetary claims, specified claims. The obligee may exercise a right belonging to the obligor, in order to ensure the performance of certain non-monetary obligations. It is possible to ensure stable enforcement by stipulating the obligation to eliminate infringements in the exclusive license agreement so as to ensure, in practice of contract, asserting the right of subrogation by a publisher as obligee. Second, establishment of a right of digital publishing is equivalent to grant a publisher a right to bring proceedings. However, it should be more explained the justification of discrimination between a publisher and other digital intermediaries. If we accept the idea of a right of digital publishing Third, Kaizen emphasizes that its proposal, to establish a right of digital publishing, helps to facilitate the practices of a contract within a document between the copyright holder and a digital publishing rights holder. However, according to the research of the Japan Book Publishers Association, we can see a rise in the percentage of the practice of a contract within a document. It was only 46.6% in December 1997, and gradually had increased to 59.6% in November 2005. In the research in April and May in 2010, the proportion of written contract was 77.2%. It apparently shows gradual increase of percentage of practice of written contract in this sector. Therefore, I suppose it is unnecessary to establish a new right based on a contract for facilitating the practice of written promises. To be concluded, I believe that we do not need to revise the Copyright Act to introduce any new rights, both of a digital publishing right and a neighboring right, at this moment.